Hello everyone, this is Rajiv S. Khanna for immigration.com, law offices of Rajiv S. Khanna PC. I wanted to talk to you folks today about an issue that has become problematic in the last 4 or 5 years about fraud or misrepresentation. Very often I see that government very casually throws in an implication that you have committed a misrepresentation. Actually, they will come out and say it, that we find misrepresentation. You will think this is a normal, ordinary thing and you might ignore it. I have seen people get into so much trouble with that fraud or misrepresentation finding. Let me talk to you about what can happen with that. First of all, a fraud or misrepresentation finding can lead to criminal prosecution. You can be prosecuted criminally if the government so chooses. I have seen companies being prosecuted for amazingly trivial things. I have seen government start with a 43 count indictment of a company and then walk away with failure to report change of address or something so trivial that it makes you wonder, why did the government spend $2, $3, $4 million on the prosecution of these kind of cases? We have provided advice and help to various defense teams all over the country in criminal defense of these kind of cases. My bottom line approach in these cases is you've got to be extremely careful the moment you see any implication or finding of fraud or misrepresentation. Speak with counsel, speak with somebody who knows all sides of this picture. Unfortunately, what happens is if you are only concerned with benefits like an H1 or an F1 or an L1, you probably won't pay too much attention to ancillary findings other than the fact that it has been denied. Okay, so let's talk about what can happen if there is a fraud or misrepresentation finding a little bit more in detail. The worst thing that can happen is a criminal prosecution. Okay, you can go to prison over this, and make no mistakes. If there is in fact a finding that was not rebutted, and then there was a subsequent investigation and more evidence was collected, I'll give you this, criminal prosecution and conviction is not as easy as just throwing out a finding. And it's surprising how easily USCIS and other agencies toss around that finding, oh, this is misrepresentation. Okay, the moment I see that word, I know it's a buzzword for us to go all out for this issue and make sure the government has it on the record what our side of the story is. So criminal prosecution, not easy, but it can happen. Be careful. Deportation, removal, exclusion. What does that mean? If you are in USA on a visa, F1, B1, H1, L1, any visa, and they find that there is some fraud or misrepresentation in your past or present, the government can initiate deportation, more accurately removal from USA, and you can be then barred from coming back to USA for up to permanently. And I'm saying that again so that you folks understand. Any attempt to procure a visa or immigration benefit, note that, attempt. You don't have to be successful. Even an attempt is a permanent bar from entering USA. There is, as I recall, there is only one waiver available based upon a family member, immediate family member who is a US citizen or permanent resident. But then you have to convince the USCIS that you should be given that waiver, and there is extreme and exceptional hardship on your relative. I recall that is the waiver that is available for these things. Third thing that can happen is denial of sought benefit now or in future. So think about this very carefully. You applied for an H1. For some reason they said, oh, your degrees are fraudulent. And I've seen these kind of cases. They thought the degrees were fraudulent merely because there was no confirmation of certain kinds of things. For example, you just gave your transcripts. You did not give your final diploma. and USCIS, after doing some cursory checks, decided that you had not been able to prove your case. Instead of merely saying you've not been able to prove your case, they will throw in something like that very casually, saying, oh, this is a misrepresentation. Next thing is, you get stuck. When you apply for an H1 again, they will pull up the old record and they'll say, oh, you have a misrepresentation. We cannot give you the benefit. So in future, this can come back and haunt you. Next thing that can happen is, if there is any misrepresentation finding, let's say you applied for an H1 transfer and they found fraud, they can revoke whatever they have given you. Okay. Now remember, when I say find fraud, they don't even, this is very sad, but they will just throw in a finding without considering, and I've seen too many cases like this. It's awful what the government, and I don't think government, let me rephrase that. I don't think any government officer individually is IQ challenged, but I think as an organization, the moment we get into a bureaucracy, we are dealing with a very, very unintelligent bureaucracy. Without considering the consequences of what they are doing, they will throw in a finding of misrepresentation. So your benefits can be revoked, and you can, as I said earlier, you can get into a permanent bar from entering USA. So next question is, when does this come up? Okay, normally when a fraud or misrepresentation finding is made, typically where do they make this finding? They can do it at the consulate during visa application. I talked with some individuals yesterday. Such an easy case, and because of a misunderstanding, it became a complete problem. What was the case? Boy and girl meet, they get married according to South Indian ceremonies. I don't want to say exact state, but South Indian ceremonies. The marriage occurs in a temple. According to the law of the state where the marriage was entered into, until the marriage is registered, it is not valid. However, when the lady goes for a K1 interview, K1 is for fiancés. If you are married, you cannot get a K1. Okay? The consular officer grilled her quite thoroughly and decided that she was lying and that she was already married. Next thing, they put a permanent bar on her. Now she's in the permanent bar. The husband is scrounging around trying to get some way of getting her back in. Of course, she'll make it back in this particular circumstance because there is a bunch of factors that go in her favor, but it's a tough case. And normally, US citizen spouses, I actually, unless there is a unique case, I usually tell people don't even hire a lawyer. I mean, I hope this is ethically okay. I think it is. When I'm in my judgment, certain cases don't need a lawyer. Typically, spouse of a US citizen is such a plain and easy case. But look at this example, how badly this got messed up. So now, during a visa application, you've got a bar. What other circumstances? Remember the Tri-Valley University? A lot of you people might remember that. There were some misrepresentation implications for a certain group of people, not everybody. They had a lot of problems getting visa stamping again from the consulate. Second place where it can happen is at the airport. Okay? When you land at the airport and USCIS starts questioning you, the CBP, it's Customs and Border Protection. There are so many agencies, sometimes it's hard to keep track. When you land at the airport, you don't deal with USCIS. USCIS deals with you when you get inside USA. At the airport, you're dealing with CBP, Customs and Border Protection. They can haul you up there. I've seen cases where somebody said, "Oh, I'm coming in for a visit," and the CBP officer went through the luggage of the individual, and they found letters showing that they were meeting up with some potential employers, or they were applying to schools. Immediately, there is a fraud implication, and the next thing is, two things can happen. If they want to be kind, they will let you withdraw your application for admission and tell you to take the next flight back home without coming into USA. If they want to throw the book at you, they can actually, there's a third possibility. Second is if they levy an exclusion on you, which basically means we are formally denying you entry into the United States. Now you are barred for 5 years from coming back. But to throw the book at you, they would deny you entry based upon a misrepresentation. Now you have a permanent bar. Okay, so these are not simple matters, ladies and gentlemen. These can be quite complex. Please make sure you have competent help if you see any implications of fraud, any chanting of fraud in your applications. Okay, then the next is you can have a fraud or misrepresentation come up during a benefits applications. One example I want to give you, actually let me get to that when I get to green cards. In H1, hiring without a project, government now considers that to be fraud. I don't know how, at what point of time, hiring somebody without a project became a matter of a fraud. I still think the jurisprudence, the law in this area is very poorly developed and poorly managed. But who wants to take a chance with the criminal court? Who wants to go in and spend $800,000, $1 million defending yourself if the government wants to take the stand that this is fraud? So don't hire somebody without a project employers. That's now considered to be a fraud. I have seen indictments that said that specifically. Inaccurate job duties. An H1 employee is supposed to be a system administrator, but they are working as a software engineer, developing and not doing any administration. That can be a problem. Why? It can be a problem in depressing wages. System admins are typically, well, it could be the other way around, paid differently than a software engineer. Actually, if you hire somebody at a lower wage but make them do a higher paid job, that's a problem, obviously. Okay, I have seen failure to post LCAs at client sites. If you have employees working at end client sites, I have seen government try to make a fraud case out of that because, well, partly I think it's justified. There's something that we've got to look at very carefully because they can say, look, when you signed the LCA, you made a representation to the government. I have posted this application at the end client site, and that gets quite complicated. Okay, so this was H1. There's many examples. I mean, I could sit here and talk about it for hours, but I just want to give you kind of a flavor of when these things happen and come up. Green cards. I remember a very weird case where when filing the green card application, the PERM application, the employer, who's a fairly good-sized company, signed the application without reading it through. Okay, the 9089 was prepared by lawyers, and it was not mentioned that the employee is related to the company president. It was his brother. Okay. Next thing is USCIS denied the I-140, and on top of that, they said this was misrepresentation. We are also revoking the labor certification. When I gave a consultation on the case, I immediately moved in and we took certain steps, and I'll get to that when I come to the next topic, which is what should you do. But the point is, government's contention was that look at the 9089, ETA 9089, the PERM application. It says, I have read this application. It specifically says that. So if you are signing that as an employer or even an employee, you better read and make sure all the material information in there is correct. I have seen this issue come up a lot during adjustment of status. Where does it come up the most? Well, most lately, it has come up when government says, look, you were on H1 and you were authorized to work for an area in California, but you worked in Chicago. Here is the employee who's stuck with the fact that they cannot do anything about where the LCA was filed by the employer, but now they've got a fraud implication on their record. Okay, well, we deal with it. We make matters clear. We explain the law to the government, but it still is quite hassle-some and bothersome to be in that situation. Okay, I don't even know if hassle-some is a word. Anyhow, go ahead and be careful and watch those. Whenever you see the fraud or misrepresentation come up, just make sure it's been taken care of and properly addressed. When else during adjustment of status? Oh yeah, G325A. When you file the G325A, which is the biographical statement, government can take. I have a case actually, in which the employee neglected to mention 2 or 3 jobs that they had done illegally. Okay, it was definitely an oversight, no question about it. Because he disclosed other things, and if he was going to try to deceive the government, he would have done a lot more than merely omit those 2 jobs. So that became a big problem. They are trying to bar him permanently. We have an MTR, a motion to reopen, pending against that. During naturalization, there's an interesting case, interesting for me, but sad for the people who are involved. A gentleman ran a company, again, a relatively good-sized company. And somewhere about 6 or 7 years ago, they had submitted a letter from an end client in support of an H1, which the government considered to be fraudulent. They said they couldn't verify the letter, and they made no, I don't remember them making an express finding of fraud, but they did say that they were not able to verify, so there is doubt as to the veracity of the document. Doubt as to the veracity. Okay. That does not alert you. You don't think, well, they're not saying this is fraud. Well, that's what they're saying. Okay. 6-7 years later, they've got a lot of approvals for their H1s after that. Green cards, no problem. Employees have been doing fine. The issue never came up. This gentleman applies for naturalization. Guess what? Barred from naturalization. The government may go after his green card. Why? There is fraud. So this issue comes up in naturalization. It can come up in courts. Sometimes you are there for an unrelated proceeding, for example, divorce. Next thing is there is a misrepresentation element or an element of fraud that you hadn't considered, and you're stuck. The worst case that I have seen come up, which was very unfair and sad, is when an employee on H1 fell out of status for a month or so. Under the law, if you are out of status for even 1 day, by operation of law, your visa is considered to be cancelled. So this visa stamp that you have on your passport is cancelled. Nobody knows this law. Very few people know this law. Of course, as they say, ignorance of law is no excuse. But when a law is so complex and so difficult to keep track of, who can know when something has been voided or made invalid by operation of law? Nobody can keep track of that. It's something that happens quietly, perniciously in the background. Okay. So when this gentleman applied for adjustment of status, his 485, government said your last entry into USA was fraudulent because you used a visa that was void by operation of law. I don't think he's going to have much trouble ultimately, but he is definitely being dragged around for misrepresentation. See, I don't mean to imply that government is always unreasonable, but they can be. Individual officers can sometimes be very, very unreasonable and overzealous in what they feel is the right application of the law. Okay? What should you do? What should you do? Look at the left-hand side of the screen. What should you do? Clarify the record even if you lose the case. You want to make sure your story, your side of the story is on the record. I don't care if you lose the case. So what did we do in that? Remember I talked about the president who signed the 9089 not realizing that he had signed saying that they were not related to each other, the beneficiary and him, and they were brothers. So what we did was we immediately filed an appeal, and the appeal got dismissed, but we told our entire story. We explained what happened. We went through the entire document trail. We submitted documents. And I think even though the company may not realize it, by doing that, they have now put their own story on the record. So tomorrow, if this issue ever comes up, whoever at USCIS is reviewing his case, they can see both sides of the picture before they deny any future benefits like naturalization. Now we have both sides of the story there. Appeal it, file a motion to reopen, even file a lawsuit. Okay, all of these things you can do. And what else can you do? If nothing else, send out a letter. Make it clear what the record was. I believe that should at least provide you a modicum of good defense. Good luck, folks, and it's good talking with you. I think I want to do a video next time about these I-140 revocations. I'm seeing I-140 revocations coming up after 8-10 years of having been approved. Highly unfair. Let me get into that next time, hopefully tomorrow. Good talking with all of you. Thank you for listening.